Welcome. This is the Domain Name Law Show. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. I'm one of your hosts, Todd Ryan. There's three of us, Jeff Neuman and David Michaels. I'd like to get things rolling by saying hello to my co-hosts. Hey, Jeff, how's everything going today?
Hey, sorry, except for my voice failing. Good. Everything's going well, pretty busy, lots of stuff going on, and lots of interesting cases today. I think there's definitely a theme in the cases today, so I'm excited to get rolling.
Yeah, I wanted to mention before I say hello to David so next week I wanted to talk a little bit about the .in extension. I mentioned last week that we were going to touch on it today, but I didn't put it on the outline for a couple reasons. One, I wanted to do some more research and about what's been going on with the .in extension, but more so since we had four cases today, and it's a busy week for a lot of us. I know for myself, for Jeff and David, it's so I wanted to jump into the four cases today. We normally should just do three here, two or three, frankly, because it's just so much to you know go through these cases and try to extract some sound intelligent but extract the good points from each case. So four is a little too much, but you're right, Jeff, there's a theme to them, and I wanted to go through these four cases today. So next week we're going to talk a little bit about the .in extension, and we're going to touch on again, I have on the outline about the new next round of GTLDs. Jeff and I are going to do an hour show just about the GTLDs, and I have some other folks who really want to participate in that. But so we're getting things organized here. It's just been very busy time. But anyway, thanks for joining us, and if you're on replay, thanks for joining us. As you guys know, we stream right now on YouTube as well, and then we have replays on Spotify and Apple. But David, how's everything going with you? Everything sort of warming up a little in your area, or still cold, but how is it?
It's cold, but not as cold as last week. So sunny at least, and that's nice. And I'm really happy about the Monaco.com decision. Has some really great points in there.
Well, I was hoping that Igor, who was a panelist on that case, and then John Berryhill was John wasn't on the Monaco case, was he? No, John was on the yeah, he was. Okay, because he's in two cases today, the Gaines case and the Monaco case. Okay, so we're
John's in the middle of every,
yeah, so
John's in the middle of everything.
a lot of sort of cool cases, but yeah, when I first saw this one, so we're going to jump right in. I felt like if Igor was here, he'd have a lot to say, obviously, about the case because he was a panelist here, and you never know, John may drop in too, but hopefully they're listening anyway. I'll listen on the replays. So I'll be on the lookout for them. But I'll give you a few facts, and then David, I'll throw it to you, and then Jeff, you comment after David. But I was going to say, okay, so the domain in the first case is monaco.com, monaco.com. What a great name anyway, as a brandable. But we all know there's country, Monaco. And is it considered a country? Is Monaco considered a country? I know Monte Carlo's the sort of the city there, but is Monaco like I should know. I mean, I've only watched every James Bond movie, but or is it a what they call a I don't know. Is it its own country? You guys know
It's
Monaco.
a city-state, yes. It's a country.
Okay, but anyway, so the complainant in this case, long name Marquis de l'État de Monaco. Anyway, so it's this public company in Monaco that protects, defends, probably helps grow the Monaco brands. And the Monaco brands are two trademarks mostly. That's Monaco and Monte Carlo. Okay, well, they filed this UDRP on this domain name, monaco.com. And the name was originally registered in 1995 by a gentleman named Eugene Monaco. Okay, so, he was buying it. He passed. He leaves it to his daughter, who had a different last name, but she got a divorce in 2024 and basically reclaimed the last name Monaco. But I don't even know if that would have made a difference or shouldn't have made a difference. So in September 2025, this Noel Monaco sold the domain to a company called Irwin Incorporated, and it was under a payment plan. So an interesting point about this case is when they file the UDRP, Monaco, the city state, as Dave says, files this UDRP, it gets basically delivered to the respondent, who the respondent in this case was the escrow company. And I remember from some emails, I believe with John, that was saying that this not only was the escrow company first considered the respondent, but they even named not the escrow company, but an individual officer of the escrow company was named as the respondent. Eventually, the respondent answered this gentleman for the escrow company and said, there's actually a buyer who's, they call it the beneficial owner, that is responsible for answering this complaint, and I'm going to allow him to do it. And this beneficial buyer, this person that was buying, it hadn't paid it off yet, hired John, and then John was making the case. So Dave, I'll throw to you. Mention a little bit about, we only get to see the summary that we see. We don't get to see the actual complaint. We don't get to see the actual response. That's why it's fun to talk with parties of the case, because then they'll give us some insights on what the actual complaint said and the actual response that they, like John, provided. And then of course the panelists like Igor can say, here's, he sees it all, but we just go through basically the summary. So David, tell us a little bit about how John responded to this case, and then we'll throw it to Jeff.
So he gave an outline of the history of this name, so that was useful. And he also outlined how the buyer did his due diligence. So it disclosed its identity. It said that it was buying the name for this new venture, that it hired 30 people, that, and that they had done a trademark clearance search. And although the country Monaco, through its brand holding company, holds registrations in almost every niche class 1 through 45, it doesn't matter because there's other Monaco brands out there, and he wasn't targeting. So when she bought it, when Eugene Monaco bought it in 1995, it was reflecting his company name, Monaco Enterprises, that was incorporated in 1971. And Monaco is Ms. Monaco's actual family surname. And this new business that's acquiring it is getting it for legitimate reasons. They have 30 employees. They have raised millions of dollars from investors. They spent hundreds of thousands of dollars on preparations. And that was well documented. And that evidence served to show demonstrable preparations to use the domain name in connection with the bona fide offering of goods and services before the complaint was filed. So that's useful. But, if you ask me, Ms. Monaco is still the owner of the name until it's fully paid for. It was just being held in trust by this escrow agent, and that was explained. So yeah, the escrow agent's name is not, or identity is not disclosed. It could have been a lawyer, but they said it was licensed, so maybe it was escrow.com or something else like that. So who knows? What do you think, Jeff? What am I missing here?
Well, I mean, it's possible, like we haven't seen the agreement of the escrow provider, but it is quite possible that the escrow provider was assigned the rights with the name. Who knows what the respondent, with the buyer, the respondent, what they asked for in the agreement. Some escrow agreements, there is a complete transfer so that there's no danger of the seller actually reclaiming it back. So we don't know whether the assignment, the title had transferred to the escrow agent. This is not kind of your normal escrow arrangement where it's a quick sale and then it's merely held by the escrow agent for a couple days. I don't know what the length of time period to pay off this purchase price was, but at the end of the day, it's all about who the beneficial owner of the domain name is. And at this point, the beneficial owner was the buyer. And so ultimately the panel accepted the buyer's response, and the buyer's kind of stepping into or intervening in the process and stepping into the role of the respondent. And I think, of course, that's the right result, right? I mean, I look at this no different as uh, the situation where a registrar is acting as the registrant as a privacy provider. And it's being held in trust, essentially. So once that was decided, and once it was, yeah, the buyer is the one with the beneficial interest, then David, as you were talking about, kind of the facts fell into place. There was certainly a bona fide or preparations for a bona fide use, and
I think in this first case there was no RDNH. So, uh, matter yeah, as I'm looking at it, because they did say, but basically it was the panel noted that the mere failure of the case, that they did deny the complaint, but found no evidence that the complainant knew or should have known it could not succeed. Now, I don't agree with it, but it said because, particularly since it was unaware that the September 25 sale and the buyer's bona fide plans at the time of filing. So it was saying it didn't know that there actually was this sale that was, why did this new person buy it? Basically, they just cut him some slack. They cut the complainant slack, saying, I don't think they were trying to abuse the system. So the panel did decline to find RDNH, and that was a 3-member panel. And an interesting part of this that's not in the summary is, okay, a 3-member panel, this Asen, A-S-S-E-N, Asen Alexiev, he was the presiding panelist. Igor, as I mentioned, and I sure wish he was here to comment, Igor was one of the wings, and the other wing was Dawn Osborne, who we know of Dawn. She notoriously sides with complainants, basically brand owners, many times. And if a complainant files a case and the respondent doesn't respond, many times we'll see, if Dawn is the panelist, especially solo panelist, she'll transfer the name. In this case, apparently John had requested, when it's a 3-member panel, the complainant and the respondent's attorneys, reps, can request, make a request for, here's who they would like to be that extra panelist. All right, Jeff. I mean, so they can elect and sort of nominate panelists. In John's case, none of the panelists that he nominated were available, so it was automatically assigned. This was this was a forum case, right? I mean, I can't even remember. Maybe it was a WIPO. Now that okay, okay, check. Okay, so they basically, um, John's nominations, or who he requested to have as a third, as an extra panelist, as a wing, wasn't available. They automatically just assigned Don Osborne, from what John mentioned. And well, he basically worked out in this case, except, boy, it sure is important. He wouldn't have selected her. I know that. So it did in this case. It ended up being a complaint denied, no RDNH. So they did say, yes, Monaco, the city-state, does have a trademark, but no, they didn't successfully show that this domain owner didn't have legitimate use to it and also acquired the name in bad faith. So, we have, interesting case, but I didn't think it was a chance that it would go like the France.com case. Did you guys, any concerns about that, David, Jeff? and the respondent, I mean, his lawyer John really made a good case that, listen, Monaco, the word can be used for many legitimate purposes, and this domain owner, the new registrant that acquired from the Monaco family, in fact, did have a legitimate use and was putting together a company that was going to use it in a legitimate way. Um, I thought it was interesting. Igor let us know he did tell me that all the panelists, all three panelists, had a meeting of the minds, that no one was really resisting here. That it was not an easy decision for the respondent, but they did all agree that I still don't understand how they don't believe Monaco, the country, reverse domain name hijacked or attempted that, an RDNH, because it is pretty brazen to think just because you have a trademark that no one else can use that name. But then again, that's a lot of entities like that, countries think they. Yeah, good point, Jeff, and very important point. Uh, Jerry Levine, who is one of the panelists in two of the upcoming cases we're going to talk about today, always mentions, and it sticks in my mind, that these decisions help shape the aftermarket. So over the years, these last 25 years, these decisions, these panelists have really helped, and they've helped, and I mean more helped than hurt, certainly, develop this aftermarket. Meaning, okay, that they're showing that domains change hands, and us as domain investors will sell a name, and we don't want people to be scared to purchase a name because it may be taken away from them. Why? Because I may have bought a name, excuse me, 20 years ago before a trademark was established, and then but if when I sell that name, this new owner has to deal with their acquisition date, and in many of these cases today, I wrote down a relevant acquisition date. So they always consider in a UDRP, yeah, we don't care when it was registered, even though you got this early registration date. We're worried about when did you, as this new registrant, acquire this name? Well, many times it's in 22, 23, 24, whatever. And a recent acquisition date, it's after a trademark's established. Well, we're seeing every time, we're seeing a lot of companies notice when a domain has been sold, and then they go after that new domain owner because they can show our trademark was established before this person acquired this name, and we believe that basically they didn't want to file a UDRP when they knew they were going to lose to the previous owner because the registration date was before their trademark. But they get some guts, and we're seeing a lot of these trademarks. I mean, basically, a lot of complaints come in, and the reason I say this is an important decision is because we want potential buyers to know you do have a right to these names, even if you're acquiring it after a trademark's established. Because if we, as domain owners, kept, I was going to say new domain registrants lose these names in UDRPs, it certainly does affect the aftermarket, because then they know I'm buying a name after a trademark's established. I may not have rights to it, or it may be ruled transferred away from me. All right, boy, I sure got a long way to get to that point. Hey, Arif, thanks for joining us. You see, we got three more cases today, but what's your comment on this one?
End of the day, the government's opposed it, and ICANN had to make a decision. And so it was ICANN that stepped in and said, look, Amazon's made these commitments. We, ICANN, believe it should address your government concerns, and therefore we're going to go ahead with it. But this was opposed until the day it was delegated, and even afterwards, um, by those governments. And it's still brought up. I think, can't remember if it was the last ICANN meeting or two ICANN meetings ago. The South American governments, some of them basically made a statement saying that they are not going to let that happen again, um, and blaming, one GAC representative got up there and basically complained about the previous government rep from that country who was obviously a different political party, and used that to make a statement that said, it was because of the weakness of the previous government in that particular country that Amazon ended up being allowed to use it. So geographic names are one of the most controversial topics for the new GTLDs, and will continue to be, even though the guidebook does have rules. In fact, today there was a call between the registries and registrars, they're called the contracted parties house, and the GAC, representatives from the government, and sort of, in passing on the call, one of the governments said, was asking a question about the new round, and basically said, hey, are you guys, meaning the registries, educating future registries about not applying for geographic names and not causing an Amazon type situation? So it's still up there, controversial, um, and even in trademark law, it's very controversial. So it'll be interesting to see what happens in this next round.
Yep, there'll be some fights for sure. We're gonna be talking about them here, very likely.
Yeah, especially since some geographic names, have multiple meanings, like Greece. Greece is the word, okay, I know that's spelled different. But interesting, Montreal.com, then you have a chance to keep it when you own a CCTLD. Of course, the rules are different. Of course, we all know .ai is raising their rates. It's a separate story, separate topic, but it is true owning a CCT. Jeff, let me ask you real fast, and David, you may know since you're in Canada. So pretty easy for .ca to claw back stuff like what happened to Arif if they just feel like when it's a CCTLD, they have that much control. They just, obviously, their service provider, whoever they're using to issue out these names, but is it pretty easy process to claw back a name when you're a CCTLD?
I don't think so. I think in Eric's case, it was sold without actually delivering it. Once you have it, that's a different story.
Yeah, it was in my portfolio, but that probably didn't go through the full mechanism, especially like 25 years ago. There's probably some delays, and then when they actually tried to like add it final, there's probably something technical that happened there.
Yeah, some registrars don't do a live EPP call when they're registering certain names. They'll check to see if it's been registered, but they won't do the proper EPP call, and then they'll register it, taking the chance, or they'll attempt to register it. It'll look to the user like it went through, but then when it goes to the registry denies the registration request. So it's common, not just way back when, but it's also semi-common when there's a new GTLD launch if the registrar hasn't done the appropriate source code for checking the registry real time.
I want to take a break here and say thank you for listening. If you're listening on replay, this is the Domain Name Law Show. You can check out our website at dnlshow.com, and you can check out the outline at dnlshow.com/outline. This, we like I said, we broadcast live here on X, and we stream on YouTube. Now, the last few weeks, I noticed sometimes we have audio problems where you can hear me, but you can't hear the others. Basically, I'm using an OBS app to help, anyway, I'm getting some things corrected, so you should have less errors in the future, I wanted to say. So you can always be sure to hear a full stream right here on X, and then there should be less, there's usually zero issues here with regards to guest audio if you're listening to the X replay. YouTube replay, Spotify replay, and the Apple replay all go through the OBS app. So that's why sometimes there were issues, but I'm getting that resolved. But I wanted to say thanks for joining us. We do this every Tuesday where we talk about domain name legal news. We usually have a discussion on a few topics, and then we review some UDRP decisions, usually recent decisions, and these are all recent. Today we're doing 4 cases, so we're jumping right to it. The first case, the domain owner got to keep the name. It was monaco.com, and the city-state of Monaco was the complainant against an individual who was buying the name from the Monaco family, but the 3-member panel ruled in the favor of the domain owner. The second case, I believe it's pronounced etihad, it's etihad.ai. So this is the country code name. The complainant is Etihad Airways. So really, Etihad means united in Arabic. So keep that in mind. It's a United Arab Emirates airline. This complainant had professional representation, basically a law firm, and the respondent in this case was Hailcom. They were represented by some attorneys too out of India, but and maybe they were represented by attorneys out of India because they felt like they knew more of basically history of this complainant. But anyway, the airline has trademarks in the UAE and the US under etihad. This is the domain, the .ai, etihad. The respondent is a US-based AI professional, is what it said in the complaint. He's a domain investor. He acquired the name at auction in August 2023 for $631. So a few years ago, picked up the name at auction. He has a lot of AI names in his portfolio. Now the name resolves to a broker page and has it listed for sale at $98,500, or at the time of this complaint. But now there's no price. I think it's just a make offer. But the argument was, by the complainant, hey, this is exactly like our mark. This is unique. The guy was offering it for $100,000. That's not a bona fide use. It's wanting to get so much more than their cost on this thing. So the the complainant felt like when you're registering, acquiring a name primarily to sell it for profit, that's not a legitimate use. And then, of course, it's confusing with its trademark. Now, I'll let Jeff, I don't know if you had a chance. First, we'll go to you on this one and talk about how the respondent argued, made their defense in this case. Take it.
Yeah, I mean, I think you said the first argument they made, or one of the main arguments they made, is the fact that the transliteration of the Arabic term is etihad, and by transliteration, that just means the Arabic words, obviously in Arabic letters, but the way you pronounce it would be etihad. And so, I think that certainly was one of the main arguments. It's not like the respondent really could have argued, well, I never heard of them. It is, one of the largest, or the largest airline, or one of the largest airline providers, not just in that country, but in the world, and they operate everywhere. So the respondent did not, make any kind of argument that they never heard of it, but they argued that they are a domain name investor, and that they have a number of short generic names in the .ai space, and that there was nothing from the complainant that showed any kind of bad faith, other than the fact that obviously, at the time they registered the name, the respondent registered it, this was a trademark and it was known. But again, with the generic or descriptive meaning of this term, along with the fact that there are plenty of other users of the Etihad uh, united kind of definition or meaning. All that basically was, look, the only thing you're claiming bad faith on is the fact that it's selling it, but we've already held in a lot of cases, and it is the consensus view that merely or selling a domain name in and of itself, or being a domain name investor in and of itself, is not bad faith. And given all the other uses that the term is used in Middle Eastern branding, given the fact that there's no evidence that they reached out to the complainant to try to get them to purchase the name, all of those factors combined basically was led to a finding in favor of the respondent. And in this case, and this I was a little bit surprised about, it was also found to be reverse domain name hijacking.
just happens to be frustrating for companies who run into this, meaning this airlines thought, geez, is, I agree that it should have been an RDNH here, um, even because the reason that David mentioned, and that is so many other companies around the world use this term ETIHAD, and it can mean union, unity, united, and it's frustrating for the airline. They wanted to file, they wanted the name because they must have wanted the .ai, because there was really they didn't bring up any evidence of, look, this is confusing people, or they've changed their MX records and they're impersonating us. They weren't, contacted by this domain owner. This company just wanted the domain name, and they wanted to say it was acquired in 2023. We've been around for a long time. There's no way in hell that they didn't know about our airline. And it shows you that this domain owner may have acquired it and may have known about the airline. It still doesn't, that doesn't hurt him. It can be a popular, it's like United, right? United Airlines. If you registered United dot one of these other extensions, crazy extension, well, you might be aware that there's a United airline, but you're also aware that there's from United Way to a lot of companies that use the term United. Point is, it's for these companies, they feel like they have a right to, a name. They go after it. In this case, it was ruled a reverse domain name hijacking, so complaint denied. There was one point I wanted to make, but I think you guys covered it pretty good. Yeah, yeah. Yeah.
Can come into play, especially with, if there's one provider that's well known in the world, like Etihad in flights, airlines. Um, sure, it would have made a big difference.
So that was another complaint denied. The domain owner gets to keep the domain name. On to our next case, and that was once again too a three-member panel. So you're finding that when there's a representation, when the domain owner has lawyers, the lawyers usually say, we want a three-member panel. Request it. Although we have seen a lot in the last year or so, even with representation, they could do with a single-member panel. This next one has a lot of parties involved that you guys would know. A lot of people in this room. The domain is Gains, GAINS.com. Complainant is Axel Sylvian, something Van de Breken out of the Netherlands. He was self-represented. He's got an app, sort of a fitness personal development brand type app that he's developed since 2017. And he was saying, I have this big Instagram following and Facebook following, and I got products you can see on a website I got, and I've even sold out of some products. I bring that up because he filed this complaint against Afterthought, which is a Mars company, and John represented the domain owner in this case. So once again, John's representing the domain owner. Like I mentioned, this Dutch individual is saying he's been around since 2017 and wanted to claim that he has trademark rights. Now, he filed a U.S. and Benelux trademark application in 2025, but his applications were still pending. So what that means is you can't use a pending application to prove that you have trademark rights. So this person, this complainant, needed to really establish that they had common law rights. And I'm going to just say that they didn't do it, and that's really why this case ended up being a complaint denied. But there's some interesting points to the case, and the last I'll bring up before throwing it to you, Jeff, is the domain Gains was registered in 1997 but acquired by Amar in 2021 for 150 grand. It said for about 149,500. He doesn't mess around. So he bought this name as part of a domain portfolio. So there might have been a lot of other names in there, but if I recall, this was one of the better ones in there, and that's primary. But anyway, so since mid 2025, Amar, his company, licensed Gains, GAINS.com, to Gamer Gains Labs for a, this crypto gaming platform. So I just wanted to bring that up, telling people, yeah, if you have a, great name, or you have a name, you can lease it out to companies, especially this is somewhat generic name at, Gains. Uh, so Mar did, fantastic here, basically leasing it out. And then I guess, he was the one we see in this case had to respond because leasing it out, of course, he remained the owner. This wasn't a lease to own, apparently, like in that very, first case where the buyer, the beneficial owner in that case, was responsible for responding. So, Jeff, tell us a little bit about why it's different that Amar, the seller, or the leaser, the lessor, was responsible for responding to this UDRP, and any other facts you want to share about this case.
Yeah, so in lease to own cases, um, the lessor is still the owner up until the day that the last lease payment is due, or the ownership payment. I'm not sure this was leased to own or it was just licensed. But when it's licensed, that's even stronger, right? Because the owner of the name is in fact the entity that licenses it out. So, um, it's very different than the escrow case where the intent was from the beginning to transfer complete ownership of it. But this case, interestingly, um, died in the first element. Um, so as you said at the beginning, the complainant at this point in time, or the point in time this case was filed, it was just an application or two applications. It was just in the application phase. And, you know, that does not count for purposes of section of establishing your trademark rights. If it were a registration, yes, that's proof that you do have a trademark rights in the name. But at the application phase, it's no different than if you never filed an application. They just look at common law. And do you have common law trademark rights um, prior to the filing of this case? And this is where the complainant, well, one of the areas that the complainant was deficient on. And I think it showed things like, well, the guy who owns it has a bunch of YouTube followers, a couple million, um, and other social media followers. But it didn't show commercial transactions that actually of goods that had, or services that had that Gains branding. I think it submitted a receipt from 2017, I want to say, or maybe earlier, that I think it was 2017, that the actual complainant sold something, but it was not clear from the evidence that that something it sold bore the branding of Gains, as opposed to just the complainant's name, which was what, Axel Sylvian. Um,
Yes, it is, and I was going to mention that in a second. Yeah.
Trademark, in other words, use, in commercial use, and that without being able to establish that, you don't get past the standing element. And this 3-member panel, which I think Karen Bernstein might have been one, Doug Eisenberg, and a third panelist who was the presiding panelist, basically said, look, you can't even get past the first element. We don't have to look at the second or third element. And I think that, yes, I know that they found reverse domain name hijacking, because if you can't get through that first element, especially when it is such a common word, then don't waste the UDRP's time. I think also, if it had come down to it, let's say they did establish trademark rights, which they didn't. You also have evidence. Amar is a domain name investor. He's got a long history of it. I believe he owns a bunch of gains dot multiple TLDs, or gains is in the domain name. So he had some great evidence if it actually went past element 1, but it didn't.
Yeah, you're right. And I was looking at his Instagram page that he cited. Well, he's got 138,000 followers, building gains and documenting things on the internet. But I'm looking at his feed. It's not showing any type of business whatsoever. It's just a bunch of random stuff that has nothing to do with any kind of business. So, yeah, just because you're popular for one reason or another doesn't mean you get to file UDRPs against domain names. That's not a brand. But I was looking at the USPTO database, and there are at least 5 other trademark owners in the United States for the word gains.
Yeah, isn't there like is it laundry detergent, or is it dishwashing liquid?
Oh, that's singular. I'm talking about plural.
Oh, that's not gains plural? Okay. Either way, gain or gains is obviously a pretty dictionary term, but yeah, sorry, didn't mean to interrupt.
No problem. Yeah, like Superhuman has a brand for it. So does a clothing company for gym wear. And then there's a consulting company. A fitness company has an app. I think the consulting company has the greatest claim, because they filed their application in 1975 and they renewed the trademark recently. It's called the Gain Systems LLC out of Chicago. So, if anybody had a complaint, it would have been them. But, the domain is in use and there's no evidence of targeting. So what's the complaint about? It's a dictionary word.
What really got this guy who filed the complaint, he basically filed this complaint as a gamble, and he even admitted to it in a subsequent video, and I'll mention that real quick. But basically, what Jeff was saying, he had to establish that he was been doing businesses, gains. He showed some receipts, some screenshots, some stuff that really the panel was like, no, that's just simply not enough, and some of it doesn't even connect to the word gains. But most importantly, you sent an email to Amar or to Afterthought in 2023 saying, this is a dream of mine. I haven't really got anything going yet. But yet then you lie and say that you did have a company going. Basically, you've done plenty of business under the name Gains, but then we have an email that shows that you actually didn't. It was just a dream of yours. But okay, so after he lost the decision, this guy went on. He did have some followers and tried to say, look at all these followers. He posted a video and said, can you believe these domain people? I mean, the site's going to a gambling website. It's forwarded to a gambling website. I was taking a gamble to try to take it away from them. So the guy was like, obviously abusing the system, in my opinion, especially when he admitted it, just saying, geez, I mean, isn't it, he basically said, isn't it funny that these, people that are gambling, this type of behavior, and then they're all uppity about me trying to take it from them, when it's like, basically, I was saying the other day, den of thieves. He's like, hey, they're crooks, I'm a crook, I can't believe a crook's calling the cops on another crook. But he was mad that they were, that RDNH, and it was like basically, giving him a bad look. And he's like, can you believe that these gamblers are trying to say I'm a bad guy? But anyway, he was. So that was the domain GAINS.com. It just goes to show you, though, people will spend the $1,500, and then they had to spend a little bit more because 3-member panel to try to just steal your stuff. So they're thinking, hey, I'm willing to do that, and you really need to have a defense, because sometimes if you don't respond, that means usually it's probably going to end up being a 1-member panel, and anything can happen. We've seen great names get transferred away when you don't respond. So it's frustrating as a domain owner. This is happening more and more. You do need to hire a domain name lawyer who knows what he's doing to help you respond. By the way, thanks for listening, for the people listening on replay. And I wanted to mention, when you have a domain name dispute or really a serious legal issue, reach out to me here on the show and I'll direct you in the right direction. You can reach out right to jjnsolutions.com. That's Jeff's consulting firm, basically also his law firm. But want to make sure when you have a domain dispute, anything related to the internet or IP, it's important to have an attorney that has experience in this specific area, this specialized area of law. So that was our third case. We're going to get to our fourth one so we can get out of here. The third case was a transfer. So that was, a reverse domain name hijacking. The complaint was denied. That was GAINS.com. The final case, and we were only going to have 3 cases, but I couldn't help myself. I saw this 3-letter domain, FIN.com, that was registered back in 1999. And I was like, so this company, Financial Information Network, was represented by this, it sounds like it's an Italian law firm, but that's just the guy's last name, Italia. It's an IP firm out of California. Goes ahead and files this complaint against this other, this domain owner who's also out of California, and fortunately had some professional representation as well. So the domain FIN.com, we know can mean the end, finish, so on. Super valuable domain name. You can imagine in finance and really in anything it can be used for. But so the domain FIN.com was registered in 1999, but it was acquired by this domain owner, MINML LLC, as part of a domain investment business. And when they got the UDRP, or right at that time, they had transferred the domain to another corporation or another entity that's owned by the same company. But anyway, the registrar in this case confirmed that MINML was the registrant at the commencement of this when it received the UDRP. And even though the respondent argued that no, it's this new entity, this new domain investment company, the panel treated the original MINML as the proper respondent. But anyway, so this case, the panel, well, let me throw it to David first. David, this valuable domain name, this financial information network was the complainant. Absolutely, in my opinion, just trying to get a fantastic domain name for $1,500. It ended up being a 3-member panel because the respondent said, no, we want a 3-member panel. And we had Jerry Levine, friend of the show, was the presiding panelist in this case with Carol Stoner and Eugene Lowe. But what facts can you share with us, David, about this case, FIN.com?
I think the critical fact is that FIN is a word, and the trademark is in stylized format and has always been in a stylized format. There's 3 different versions of their trademark registrations, all the stylized formats. And I think that they the trademarks were denied, or for whatever reason they decided to use stylized applications to avoid genericness. Now, the domain name itself resolves to a website for cross-border payments using crypto, instant global settlement. It's a live site. So there's no targeting here. There's no bad faith. Is it trademark infringement? Well, that would be a different question. And did they prove that? No. So it was denied. What did you see in this, Jeff?
Yeah, I mean, I think there are a couple things that, I don't even think the complainant pointed out that it was only in stylized. So to put that into perspective, I guess for everyone is you can apply for a, you know, let's say a mark, but the mark is written in script, and you can apply for it both as stylized in that kind of script format, um, and or you can apply for it as a word mark. Often they can be. The reason I say and is because often they're combined. But in this case, the trademark owner was never going to get a trademark for for the word mark FIN, especially in connection with the services for which it was using it, finance, because everyone knows that FIN is essentially an abbreviation for finance. So, the trademark owner pretty much, I won't say lied, but it kind of hid the ball from the panel. But it's not a stupid panel. So the panel obviously did its research, at least looking into the registration. Um, in addition, I think the complainant made up some facts about some links that they argued were fraudulent or went to fraudulent content or something like that, but there was nothing in the evidence that actually showed that. And so, in addition to what David was saying about losing the case, they also found reverse domain name hijacking because um, it makes all these bare assertions on infringement and fraud and all this other stuff, but provides no evidence of that. It sort of hid the ball on the trademark registration. It didn't even mention the fact in its complaint that FIN is a well-known abbreviation for finance or financial. So with all those factors, um, they found reverse domain name hijacking, which I agree with. Like, attorneys have an obligation, yes, to zealously represent their clients, but not to intentionally hide the ball or make up facts or make arguments for which they have no support for. And, that's exactly what the complainant did here. And, and really shouldn't have done that. So, yeah, this panel, which Jerry again was on, found reverse domain name hijacking. So, of the 4 or 5 cases we looked at today, all but one of them were reverse domain name hijacking. And a case could have been made for the other one to be reverse domain name hijacking.
Sure.
Yeah, so I'm looking through the trademark application. So the goods were financial and investment services, financial planning. The company name itself is Financial Information Network. And I'm looking at 2014 office action directed to James Italia in Burbank, California. And the examiner is objecting to the trademark, saying 5 years of use is insufficient, and it's refused under Section 2F because the mark is highly descriptive. And then cites the Merriam Dictionary definition of FIN as being an abbreviation for finance or financial. So that's the nail in the coffin. Like, for hiding that in his complaint should be cause for complaint to the state bar.
Yeah, I mean, it's definitely crosses the line, as I said, between zealous advocate for your client and, you know, hiding the ball, right? Attorneys are supposed to be officers of the court, and you're supposed to point out everything in the case, whether it helps you or hurts you. Obviously, if it hurts you, you present it and then present arguments as to why it shouldn't hurt your case. But you can't just ignore it and not, um, not let the court, or in this case, the UDRP panel, know the weaknesses in your case. That's not what attorneys have an obligation to do.
Well, they're so careless. You could use the word reckless in these UDRPs. In this case, Jerry, uh, uh, lead panelist, said, "Yeah, first of all, there was no credible evidence that the respondent knew um, of the um, complainant, even though the complainant may be popular, but there's no evidence, and that he tried to exploit this, company." But it was very important. Jerry was saying you guys are very experienced attorneys on the complainant side, but yet you didn't even bring up that the genericness of the three-letter, and you didn't even really have, like you said, it was the stylized trademark. You didn't have a trademark to the word or to the letters. So not bringing that up, and being such a I say respectable, but such a experienced attorney, a law firm, that really bothered the panelists. And Jerry, it didn't pass Jerry at all. He's like, that's why he ruled, yeah, this is absolutely reverse domain name hijacking, because the case, you made all sorts of conclusory allegations, um, to turn a legitimate ownership of a valuable name into bad faith. They were just basically making statements, and the complainant's rep should have known better, but they still do this, and they know there's no recourse. So we talk about it all the time. So there was reverse domain name hijacking last year. In 2025, there were more RDNH rulings than ever before. Looks like this year it's on a roll. Looks like it's going to bypass the previous. So that is good news that panelists are saying you guys are abusing this whole process, but I don't know, it's not really deterring companies from doing it, because, as David said, there needs to be complaints to the bar, whatever state they're in. I don't try to follow up, find out, has there been any complaints to state bars? Because, and would they even accept a complaint? How would they? I mean, they should take a complaint and say, okay, so this firm or this lawyer is being reckless or careless with regards to this proceeding, a UDRP, because they will take complaints about what attorneys do, um, just basically in their how they conduct business. So I'm curious how many complaints the state bar gets for attorneys abusing a domain dispute, or abusing the UDRP. But they just keep doing it, and it's increasing that they're going after domain names, without having strong cases, or just really putting together a case carelessly. And now sometimes we'll see that you don't even know who's signing off on the complaint. Sometimes it's just an associate attorney who, you know, uh, basically a new attorney that they throw under the bus, and it's not one of the partners or a well-established lawyer. They don't want to sign their name to it. All right. Well, anyway, that was our fourth case for today. FIN.com. That was a transfer. Or I say that messing up. That was a complaint denied. All four cases today were complaint denied. The domain owners got to keep their names. Jeff mentioned 3 of them were RD and H. It's basically, that just shows that the complainant abusing the system, trying to take a valuable name from someone. And we had singular, gains.com, fin.com. As a domain investor, I'd love to own it. Love to own monaco.com. If I probably would never own etihad.ai, only because it's a .ai and I don't know all the words in Arabic. But anyway, valuable domain names, if you have them, be aware. Somebody may try to take them from you. Hey, thanks for joining us today. It's going to wrap it up. We're going to be here next Tuesday, noon Pacific, 3 p.m. Eastern. We're going to go over country code names, specifically .in. We're going to talk a little bit about the next round, and when Jeff and I can have a specific sort of tailored space just for GTLDs. But next week, you can bet here, we're going to review some recent UDRP decisions. No more than 3, I can tell you that. But thanks for joining us. Finally, I want to say this Thursday, got a full outline for the DNX show. That's our domain name investing show that I do with Josh Reason. That's right here on X, also streamed on YouTube and on Spotify and Apple. That's 10 a.m. Pacific, 1 p.m. Eastern. So that's the DNX show on Thursday. Until then, hope everybody has a great rest of the day or rest of the evening, wherever you're at. Take care of yourself. See you next time.